It was a November morning in 1946 when the doors of the small town hall of Ravenstein opened for the last time on the fate of 37 innocent civilians. The smoke from wood-burning stoves mixed with the biting cold that penetrated through windows shattered by bombardments. The families had been rounded up at dawn, torn from their homes by the force of bayonets. Elderly people, women, children, no one had resisted. There hadn't even been time to put on heavy coats. They had been herded into the main square, under the impassive gaze of Commander Erich Vollmer, an officer of the rearguard troops who had received the order to evacuate the village within 6 hours. But evacuation had never been the real objective. Vollmer had read Decree Number 732 from Military Command, a 3-page document authorizing extraordinary measures against populations suspected of supporting partisans. The key word was suspected, an elastic word, interpretable, convenient. Vollmer had decided that the entire village of Ravenstein constituted a threat. There was no evidence, no intelligence reports, no witnesses to partisan activity. Only the paranoia of an officer who wanted to demonstrate his firmness to his superiors, and the opportunity to loot abandoned homes. The inhabitants were loaded onto 3 military trucks. The journey lasted 40 minutes, along dirt roads that climbed toward the wooded hills north of the village. When the trucks stopped, the civilians were made to descend in single file. Before them opened an abandoned quarry, a natural amphitheater of gray rock and churned earth. Vollmer gave the order without hesitation. The machine guns opened fire at 8:35 in the morning. The massacre lasted less than 3 minutes. The bodies fell into the quarry like sacks of grain. Some children screamed. Many didn't even have time to understand what was happening. Vollmer compiled the report that same evening in his temporary office. He wrote that he had executed the order to neutralize hostile elements in accordance with Decree 732. He signed, stamped, filed. 9 months later, in September 1947, Erich Vollmer was tried by the Allied Military Tribunal at Nuremberg West. The court listened to testimonies from survivors, 2 farmers who had managed to escape before the roundup. It examined photographs taken by American liberators when they discovered the mass grave. It read the report signed by Vollmer. And then, incredibly, it acquitted him. The reasoning of the sentence occupied 12 typed pages. The core of the argument was simple and devastating. Vollmer had acted within his operational discretion. Decree 732, according to the court, granted field commanders the authority to autonomously assess the level of threat represented by civilian populations. There was no evidence that Vollmer had acted out of personal malice or sadism. He had interpreted his instructions in good faith, in the chaotic context of the German retreat. The responsibility, the sentence concluded, fell on the command system that had issued such an ambiguous decree, not on the officer who had executed it. Vollmer left the courtroom a free man. No prison, no sanction, no permanent mark on his record. He returned to West Germany, where he found work as an accountant in a furniture factory in Stuttgart. His life resumed as if nothing had happened. For the families of the victims of Ravenstein, that sentence was an unbearable betrayal. How could a man who had ordered the execution of 37 innocents be considered a simple executor of orders? How could the law protect someone who had interpreted a military decree in the cruelest possible way? How could justice fail so spectacularly? Among the families destroyed by that sentence was that of Martin Kreuzer. Martin was 24 years old in 1946. He was the only male child of a family of tailors who had lived in Ravenstein for 4 generations. His father, his mother, his 2 younger sisters, and his grandmother had died in the quarry. Martin had survived only because that November morning he was 30 kilometers away, in another town, where he had tried to procure flour and salt through the black market. When he returned to Ravenstein in the afternoon, he found the houses empty, doors flung open, objects scattered in the streets. It took a week before someone told him what had happened. It took another 2 months before the liberators found the bodies. Martin was not a lawyer. He had not studied law, had never set foot in a courtroom before Vollmer's trial. He was a tailor, a young man who knew how to distinguish wool fabric from cotton, who knew how to sew an invisible hem, who knew the difference between a straight stitch and a zigzag stitch. But he had a quality that many lawyers do not possess: absolute stubbornness. When he heard the acquittal sentence in the courtroom at Nuremberg West, he did not cry. He did not shout. He remained seated in silence, with his hands gripping the armrests of the wooden chair, until the courtroom emptied. Then he rose, collected the copy of the sentence that had been handed to him, and began to walk. He left the courthouse, crossed the half-destroyed city, reached the train station, and returned to Ravenstein. In the empty house that had belonged to his family, he opened the sentence and read it word by word. It took all night. In the morning, Martin had made a decision. He would prove that sentence was wrong. He didn't know how, didn't know how long it would take, but he knew he had to do it. It was the only way to restore dignity to his dead. The problem was that Martin didn't know where to begin. The sentence cited Decree 732 as the legal basis for Vollmer's acquittal. Martin had never heard of that decree before the trial. He didn't know what it was, who had issued it, what its original purpose was. All he had was the number 732. In the days following the sentence, Martin began asking questions. He wrote letters to the lawyers who had represented the prosecution, asking for copies of the decree and all legal documentation connected to the case. Most did not respond. Those who did were polite but distant. They explained that the case was closed, that the sentence was final, that there were no possible appeals in the Allied military tribunal system. They advised him to let it go, to concentrate on rebuilding his life. Martin ignored the advice. He went to Nuremberg and asked to access the tribunal archives. They told him the documents were restricted to authorized personnel. Martin insisted. He returned every day for 2 weeks, presenting himself punctually at the entrance to the archives at 8 in the morning, asking to speak with the person in charge. Finally, an archivist named Klaus, a man in his 50s with thick glasses and a marked Bavarian accent, yielded to his perseverance. He granted him temporary permission to consult public documents related to the Vollmer trial. Martin immersed himself in the archives. The consultation room was a cold and humid environment, with bare cement walls and high windows that let in pale, insufficient light. The wooden tables were scratched and stained with ink. The smell of mold and old paper was so intense that Martin had to get used to it for days before being able to breathe normally. Klaus brought him the files, heavy gray cardboard boxes tied with string. Martin began to read. The first document he found was Decree 732. It was dated March 15, 1945, issued by the Supreme Command of German Armed Forces in retreat on the Western Front. The text was surprisingly brief. 3 paragraphs, less than 300 words in total. The first paragraph authorized field commanders to adopt necessary measures to guarantee troop safety during retreat operations. The second paragraph listed examples of such measures: forced evacuation of civilians, destruction of infrastructure, requisition of goods. The third paragraph, the most important, established that commanders had full discretion in evaluating which measures were necessary based on operational circumstances. Martin read and reread the decree. He tried to understand where exactly that text authorized the mass execution of civilians. There was nothing. The decree spoke of evacuation, destruction, requisition. It did not speak of shootings. It did not speak of executions. The word kill never appeared. Yet the court had used that decree to acquit Vollmer. How was it possible? Martin searched for other traces. He examined the trial transcripts, page after page of testimonies, objections, cross-examinations. He discovered that Vollmer's defense had presented an interpretation of Decree 732 based on a legal doctrine called military necessity. According to this doctrine, a commander could adopt any measure deemed necessary to protect his troops, including the elimination of potential civilian threats, if there were no practicable alternatives. Vollmer's lawyer had argued that, in the context of the chaotic retreat, with partisans attacking German columns. Evacuating the civilians of Ravenstein without neutralizing them would have represented an unacceptable risk. The court had accepted that interpretation. But there was something that didn't add up. Martin was not an expert in military law, but he had common sense. The doctrine of military necessity had to have limits. Otherwise, every atrocity could be justified simply by invoking troop safety. There had to be laws, conventions, principles that set a boundary on what a commander could do. Martin began searching for those limits. In the following months, Martin transformed himself into an improvised scholar of the law of war. He read the Geneva Conventions of 1932, the Hague Regulations of 1907, international treaties on the protection of civilians in wartime. He discovered that there existed a detailed and binding corpus of laws limiting the behavior of armed forces towards civilian populations. The Geneva Conventions explicitly prohibited the intentional killing of non-combatant civilians. The Hague Regulations established that military measures had to be proportionate to the actual threat. Germany had ratified both treaties. Yet none of these principles had been cited in the sentence that acquitted Vollmer. Why? Martin formulated a hypothesis. Perhaps the court had simply ignored those laws. Or perhaps, more insidiously, it had accepted the defense argument that Decree 732, being a specific military order issued during war operations, took precedence over the general principles of international law. But even this interpretation made no sense. Martin knew that according to international law, no internal order could nullify an obligation derived from an international treaty. It was a fundamental principle. International law prevails over national law. If the Geneva Conventions prohibited the killing of civilians, then Decree 732 could not authorize it, regardless of how it was formulated. Martin returned to Klaus, the archivist. He asked if there were documents that explained how the court had resolved this conflict between the decree and the Geneva Conventions. Klaus shook his head. He explained that the trial transcripts contained only the arguments presented by the parties and the final sentence. The internal deliberations of the court, the discussions among the judges, the preliminary legal analyses, all were restricted. Martin could not access them. It was a dead end. Martin left the archives that evening in a state of deep frustration. He had spent 3 months reading documents, taking notes, trying to understand the legal logic that had led to Vollmer's acquittal. And all he had found was a black hole, a point where the law seemed to simply vanish, replaced by an arbitrary interpretation that favored the guilty party. It was as if someone had deliberately hidden the truth. Martin did not give up. If he could not access the court's deliberations, he would search for other sources. He began writing letters to experts in international law, university professors, lawyers specialized in war crimes. In most cases, he received no response. But one letter reached Professor Heinrich Adler, an elderly jurist who taught international law at the University of Heidelberg. Adler was one of the few German experts who had publicly criticized some of the Allied military tribunal sentences, arguing that in some cases judges had applied inconsistent legal standards. Adler replied to Martin with a 4-page letter, written by hand with elegant but difficult-to-decipher handwriting. In the letter, Adler explained that the Vollmer case was only one of many in which military tribunals had struggled to reconcile national military law with international law. The problem, Adler wrote, was that Allied judges often lacked deep training in continental war law and tended to interpret German military decrees through the lens of their own legal tradition, which was more permissive toward commanders' discretion. Furthermore, Adler suggested there could be another explanation. It was possible that the court had deliberately avoided applying the principles of the Geneva Conventions for political reasons. In 1947, the Allied powers were already negotiating the reconstruction of West Germany as a bulwark against the Soviet Union. Condemning German officers too harshly for actions committed during the war could have complicated future cooperation. Adler concluded the letter with a suggestion. If Martin really wanted to prove that the sentence was unjust, he had to find evidence that the court had ignored or suppressed a clear legal precedent that would have obligated it to convict Vollmer. That evidence, Adler wrote, could exist in the archives of the German military command or in documents seized by the Allies during the occupation. Martin read Adler's letter dozens of times. Each time, he stopped at the last sentence, evidence that the court ignored or suppressed. That sentence became his obsession. If there really existed a legal precedent that should have been applied to the Vollmer case, where was it? And why had no one cited it during the trial? Martin began a new phase of his research. He temporarily left the Nuremberg archives and headed south to Munich, where the Allies had centralized much of the documentation seized from the German army. The Munich Military Archive was a massive building, a former barracks converted into a document depository. The halls were immense, with metal shelving extending from floor to ceiling, laden with numbered boxes. The smell was different from that of the Nuremberg archives. Less mold, more dust and metal. The lighting was dim, with electric lamps illuminating only the main corridors. Martin obtained permission to consult documents related to the German military command of the Western Front for the period between March and May 1945, the period in which Decree 732 had been issued and in which the Ravenstein massacre had occurred. The documents were organized by military unit and date. Martin began reading operational reports, dispatches, daily orders. It was exhausting work. Each box contained hundreds of pages, many written by hand, with incomprehensible military abbreviations and references to units and locations that Martin had to look up on separate maps. He spent 8, 10, 12 hours a day in the archives, with only brief breaks to eat a sandwich and drink coffee. His fingers became stained with ink and dust. His back ached from the hunched posture over documents. His eyesight tired under the insufficient light. But he continued. After 3 weeks of research, Martin found something. It was a dispatch dated March 18, 1945, 3 days after the issuance of Decree 732. The dispatch was signed by General Wilhelm Krantz, the commander of the sector in which Vollmer operated. Krantz was writing to his subordinate officers to clarify the application of the decree. The text was explicit. The decree authorized the evacuation and temporary detention of suspect civilians, but did not authorize summary executions without a military trial. Any commander who ordered the killing of civilians without a formal procedure would be subject to court-martial. Martin reread the dispatch 3 times to make sure he had understood correctly. It was incredible. General Krantz, Vollmer's direct superior, had clarified that Decree 732 did not give carte blanche to kill civilians. There was a limit, a procedure to follow. Vollmer had completely ignored that limit. He had ordered the execution of 37 civilians without any trial, without any formality. According to Krantz's dispatch, Vollmer should have been subjected to court-martial. Martin felt adrenaline coursing through his veins. He had found the evidence. But then, as he continued examining the documents, he realized a problem. Krantz's dispatch had not been cited during Vollmer's trial, neither by the defense nor by the prosecution. It was as if it didn't exist. How was it possible? The dispatch was an official document, signed by a general, filed in the command system. It should have been easily accessible to Allied investigators. Martin formulated another hypothesis. Perhaps the dispatch had never reached Vollmer. Perhaps Vollmer was not aware of it when he ordered the execution of Ravenstein's civilians. If so, one could argue that Vollmer had acted in good faith, interpreting Decree 732 according to his understanding, without knowing that his superior had imposed limits. But even this hypothesis didn't hold up. Martin searched for other documents and discovered that Krantz's dispatch had been transmitted to all units of the sector via military telegraph on March 18th. Vollmer was the commander of one of those units. He should have received it. Martin decided to verify. He returned to the Nuremberg archives and asked to consult Vollmer's personal documents seized by the Allies after his capture. Among those documents, he found the operational log of Vollmer's unit for March 1945. The log recorded all messages received and sent by the unit. And there, on the date of March 18th, there was a line, "Received Krantz dispatch on application of Decree 732. Vollmer had received the dispatch. He knew it. He knew he could not execute civilians without a trial. And he had done it anyway. The Ravenstein massacre had occurred on November 5th, more than 7 months after Vollmer had received Krantz's dispatch. There was no possibility of error, misunderstanding, good faith. Vollmer had deliberately violated his superior's instructions. He had committed a conscious war crime. Martin now had the evidence he was looking for. But the most disturbing question remained. Why had that evidence not been presented at the trial? Martin returned to Professor Adler with the documents he had found. Adler examined Krantz's dispatch and Vollmer's operational log with meticulous attention. After an hour of silence, Adler looked up and said, "This changes everything. If this dispatch had been presented at the trial, Vollmer could not have been acquitted. The court would have had to convict him." Martin asked, "But why wasn't it presented? The prosecution must have found it. It was in the German military archives." Adler shook his head. "Not necessarily. The military archives after the war were chaos. Tons of seized documents, disorganized, scattered in different depots. It's possible the prosecution simply didn't have the time or resources to examine everything, or—" Adler paused. "Or what?" asked Martin. Adler hesitated. Then he said, "Or someone deliberately chose not to present it." Martin felt a cold shiver down his spine. Why would someone do that? Adler explained, "In 1947, the Allied military tribunals were closing. There was political pressure to conclude trials quickly and move on to the reconciliation phase with West Germany. Some cases, especially less sensational ones like Vollmer's, were seen as embarrassing obstacles. Acquitting them quickly was more convenient than facing the complexity of a conviction based on subtle interpretations of military law. Presenting Krantz's dispatch would have made the case more complicated, would have required more time, more resources. Perhaps someone in the prosecution decided it wasn't worth it." Martin was shaken. Was Adler saying that Vollmer's acquittal had not just been a legal error, but a political decision? Adler saw his expression and added, "I can't prove it. But yes, I believe it's possible. And if so, then your fight is not just against a judicial error, but against a system that chose to sacrifice justice for reasons of convenience." This revelation transformed Martin's mission. He was no longer trying to correct a technical error in a sentence. He was trying to expose a conspiracy of silence, a deliberate concealment of truth for political reasons. But how could he prove it? Krantz's dispatch and Vollmer's operational log were solid evidence that Vollmer had committed a conscious crime, but they were not evidence that the prosecution had deliberately hidden that information. Martin needed something else. He had to find someone who had participated in the trial, someone who could confirm that the prosecution was aware of the dispatch and had chosen not to present it. Martin began searching for members of the prosecution team. Vollmer's trial had been conducted by a team of 4 Allied military lawyers, 2 Americans, 1 British, and 1 French. Martin managed to track down 3 of them. The first, American Major Robert Dawson, had returned to the United States and worked as a district attorney in Pennsylvania. Martin wrote him a detailed letter, explaining his research and asking if he remembered the Vollmer case. Dawson replied after 6 weeks. His letter was brief and formal. He wrote that he vaguely remembered the case, but had no specific details. He suggested Martin contact the official archives. He did not mention Krantz's dispatch. The second, British Captain Edward Hargreaves, never replied. The third, French Lieutenant Jean-Pierre Moreau, agreed to meet Martin. Moreau lived in Paris, where he worked as a civil lawyer. Martin took a train to France, a 12-hour journey that took him through landscapes still marked by war, half-destroyed cities, rebuilt bridges, fields riddled with craters. The meeting with Moreau took place in a café near the Seine. Moreau was a middle-aged man, thin, with gray hair and a tired air. He greeted Martin with courtesy, but with a certain wariness. They ordered coffee and croissants. Martin pulled out the documents he had found, Kranz's dispatch and Vollmer's operational log. He placed them on the table in front of Moreau. Moreau examined them in silence for several minutes. Then he looked up and said, "Where did you find these?" Martin explained his research, the months spent in archives, the difficulties, the dead ends. Moreau listened without interrupting. When Martin finished, Moreau said, "These documents would have changed the outcome of the trial." "I know," said Martin. "Then why weren't they presented?" Moreau hesitated. Then he said, "I don't know. I wasn't the one deciding which evidence to present. That responsibility was Major Dawson's. I only handled witness interrogations." "But did you see them? Were you aware of these documents?" Moreau stared at his coffee cup. Then he said slowly, "I remember that during trial preparation, Dawson received dispatches from German military command. He said most were irrelevant, routine orders, administrative reports. I don't specifically remember this Krantz dispatch, but it's possible it was among those documents. Dawson decided not to present them because he felt they unnecessarily complicated the case." Martin felt anger rising. Unnecessarily complicated? This dispatch proves that Vollmer knew what he was doing was illegal. Moreau raised his hands in a defensive gesture. "I'm not justifying the decision. I'm just trying to explain what happened. Dawson was under pressure. He had a dozen cases to handle simultaneously. The Vollmer case was not a priority. There were no high-profile victims, no media interest. Dawson wanted to close it quickly. Presenting this dispatch would have meant opening a deeper investigation, searching for other documents, perhaps requiring General Kranz's testimony. It would have required weeks, perhaps months. Dawson didn't have that time. So he sacrificed justice for convenience," said Martin bitterly. Moreau didn't respond immediately. Then he said, "Yes, I believe so." Martin asked, "Would you be willing to testify about this? To declare that the prosecution was aware of evidence that could have changed the trial's outcome?" Moreau shook his head. "No, I can't do that. I would be risking my career, my reputation, and anyway, it wouldn't change anything. The case is closed. There's no appeal. Vollmer was acquitted. It's over." Martin stared at him. Then he said, with a calm but firm voice, "For you, it's over. For me, for the victims' families, it's never over." Moreau looked down. Martin collected the documents, left some coins on the table to pay for the coffee, and left. The return from Paris was long and depressing. Martin had obtained indirect confirmation that the prosecution was probably aware of Kranz's dispatch, but he had not obtained usable testimony. Moreau had refused to speak officially. Dawson had ignored him. Martin was again at a dead end. But he still had one card to play. During his research, Martin had discovered that General Wilhelm Krantz, the author of the dispatch, had survived the war. After a brief period of detention as a prisoner of war, Krantz had been released in 1947 and had lived in a small Bavarian town until his death in 1953. Martin could no longer interview Krantz, but perhaps there were documents, letters, memoirs that Krantz had left. Martin contacted Krantz's widow, a 70-year-old woman named Helga, who still lived in the house she had shared with her husband. Helga was surprisingly available. She invited Martin to visit her. The house was modest, a single-story villa with a well-kept small garden. Helga welcomed Martin with tea and biscuits. She explained that after her husband's death, she had kept all his personal documents, not because she thought they would be important, but simply because she hadn't had the heart to throw them away. Martin asked if he could examine them. Helga led him to an upstairs room, a small study that Krantz had used as an office. There were 2 wooden cabinets full of files. Helga left Martin alone. Martin began searching. The documents were a mixture of personal correspondence, military reports, photographs, notes. Martin spent hours examining every sheet, every page. He was about to give up when he found something unexpected: a diary. It was a leather-bound notebook with yellowed pages and minute handwriting. The diary covered the period from January to June 1945, precisely the period in which Krantz had issued the dispatch on Decree 732. Martin began reading. The first pages were daily accounts of military operations, boring and technical. But then, on the date of March 20th, 1945, 2 days after issuing the dispatch, Krantz had written a more personal annotation. He wrote of his concern about how some of his subordinate officers were interpreting Decree 732. Krantz wrote, "I issued the clarifying dispatch because I fear some commanders are using the decree as an excuse to commit atrocities. The decree was intended to facilitate the orderly evacuation of civilians in dangerous zones, not to authorize massacres. I have received unconfirmed reports of summary executions in several villages. I have ordered investigations, but the situation in the field is chaotic. I fear many crimes will never be discovered or punished. This torments me. We have already lost the war. We must not also lose our humanity." Martin felt a lump in his throat. Krantz knew. He knew the decree was being abused, and he had tried to stop it. But evidently he had not succeeded. Martin continued reading. On the date of November 7th, 1945, 2 days after the Ravenstein massacre, Krantz had written, "I received a report from Commander Vollmer. He says he evacuated a village suspected of partisan activity. The report is vague, but I fear the worst. I ordered Vollmer to present himself for interrogation. He never presented himself. 3 days later, our unit was overwhelmed by the Allies. Vollmer was captured. I could not pursue the investigation. This failure will haunt me forever." Martin had found the smoking gun. Krantz had not only issued the dispatch prohibiting summary executions, but had also identified Vollmer as a possible war criminal and had attempted to prosecute him. The only reason Vollmer had not been subjected to court-martial by the German army was that the war had ended before Krantz could complete the investigation. Martin asked Helga if he could take the diary with him. Helga consented, on condition that Martin return it when he was finished. Martin returned home with the diary, feeling for the first time in years close to an authentic victory. But now came the most difficult part. What to do with this evidence? Vollmer's trial was closed. There was no possibility of reopening it in the Allied military tribunal system. Vollmer had been acquitted, and that acquittal was final. Martin consulted Professor Adler again. Adler examined Krantz's diary and said, "This is extraordinary. It proves not only that Vollmer violated his superior's instructions, but also that his own army considered him a criminal. But as you said, the trial is closed. There's no legal mechanism to overturn the sentence." Martin asked, "What if we presented this evidence to another court? A German court, for example?" Adler shook his head. "German courts have no jurisdiction over cases already judged by Allied military tribunals. And anyway, Vollmer was acquitted. He cannot be tried again for the same facts. It's the principle of ne bis in idem, the prohibition of double jeopardy." Martin felt crushed. He had the evidence. Overwhelming evidence. But he had no court where to present it. Adler saw his desperation and said, "But there's another possibility. You could use this evidence not to prosecute Vollmer, but to establish a legal precedent. You could write a legal memorandum, a detailed analysis demonstrating that the Vollmer sentence was legally erroneous. You could then publish that memorandum, circulate it among international law experts, use it to influence future similar cases. It wouldn't be retroactive justice for Ravenstein, but it could prevent similar injustices from happening in the future." Martin reflected on that proposal. It wasn't what he wanted. He wanted Vollmer to be recognized as guilty, wanted him to pay for what he had done. But perhaps Adler was right. Perhaps the only possible justice at this point was preventive justice, a lesson for the future. Martin decided to try. He worked with Adler to write a comprehensive legal memorandum. The final document occupied 180 pages. It analyzed in detail the Vollmer case, presented Krantz's dispatch, Vollmer's operational log, Krantz's diary. It demonstrated that Vollmer had violated not only international law, but also the explicit orders of his superior. It argued that the acquittal sentence was based on a misinterpretation of Decree 732 and on a deliberate omission of crucial evidence. The memorandum concluded that cases like Vollmer's highlighted the need for more rigorous legal standards in war crimes trials, standards that would not allow commanders to hide behind opportunistic interpretations of ambiguous military orders. Adler helped Martin circulate the memorandum. He sent it to colleagues at major European universities, to human rights organizations, to international law experts. The response was mixed. Some ignored the document. Others criticized it as a post hoc attack on a legitimate sentence. But some took it seriously. A group of professors from the University of Geneva invited Martin to present his work at a seminar on the law of war. Martin accepted. It was the first time he spoke publicly about his case. The seminar room was small, with about 30 people present, mostly academics and law students. Martin presented the Vollmer case, explained the evidence he had found, exposed his analysis. When he finished, there was a long silence. Then one of the professors, an elderly international law expert named François Dumont, raised his hand and said, "Mr. Kreuzer, you have done extraordinary work. But I wonder, what is your ultimate goal? What do you hope to achieve with this research?" Martin thought for a moment. Then he said, "I want the truth to be recognized. I want the world to know that my family and 34 other innocent people were killed not by mistake, not by military necessity, but by the deliberate cruelty of a man who knew exactly what he was doing. And I want that in the future. Men like Vollmer cannot hide behind legal excuses when they commit atrocities." Dumont nodded. "You have done more than demonstrate an injustice. You have identified a systemic gap in the way military tribunals handled these cases. Your analysis could have important implications for the development of international law." Those words were a turning point. In the following months, Martin's memorandum began to circulate more widely. It was cited in academic articles, discussed at conferences, mentioned in debates on international justice. It did not bring Vollmer back to trial, but it contributed to a broader change in understanding how war crimes should be judged. In 1959, 12 years after Vollmer's acquittal, something unexpected happened. A young German prosecutor named Klaus Bauer was working on a case similar to Vollmer's. A former Nazi officer accused of having ordered the execution of civilians during the war. The defense lawyer had cited the Vollmer sentence as precedent, arguing that his client had acted according to the operational discretion granted by military law. Bauer had read Martin's memorandum. He decided to contact him. Martin and Bauer met in Frankfurt. Bauer explained his case and asked if Martin would be willing to testify as an expert, presenting his analysis of the Vollmer case. Martin accepted immediately. The trial took place in the spring of 1960. Martin testified for 3 days. He presented Kranz's dispatch, Vollmer's operational log, Kranz's diary. He explained in detail how the Vollmer sentence had been based on a misinterpretation of military law and on an omission of evidence. The defense lawyer tried to discredit Martin, arguing that he was emotionally involved and that his analysis was tainted by personal bias. But Martin remained calm. He responded to each objection with precision, citing legal sources, presenting documents, demonstrating the solidity of his research. The court ultimately issued a sentence that represented a historic breakthrough. The judge wrote that the Vollmer sentence, although issued by an Allied military tribunal, could not be considered binding precedent because it was based on a misinterpretation of international law and on an omission of crucial evidence. The court established that military commanders could not invoke operational discretion as an excuse to violate fundamental principles of the law of war, such as the prohibition of summary executions of civilians. The court sentenced the defendant to 25 years in prison, but the most important part of the sentence was the language it used to describe the legal principle. The judge wrote, "A military order, however ambiguous in its formulation, cannot be interpreted in a way that authorizes the violation of customary norms of international law. The protection of civilians in wartime is not subject to individual discretion, but is a binding obligation that prevails over any internal order. A commander who deliberately kills civilians, knowing that such action violates the explicit instructions of his superior, commits a war crime for which he cannot invoke ignorance or military necessity as a defense. This principle, which became known as the Kreuzer principle in honor of Martin's work, was incorporated into German jurisprudence on war crimes. In subsequent years, it was cited in dozens of cases, not only in Germany but also in other European countries. It influenced the drafting of the United Nations Convention on War Crimes of 1968. It became part of the corpus of international humanitarian law. Martin continued his work for another 20 years. He never returned to the tailoring trade. Instead, he became a self-taught expert in international law, a consultant sought by prosecutors and human rights organizations. He testified in numerous trials, always carrying with him copies of Kreutzer's dispatch and the diary that had initiated his crusade. In 1979, Martin received a letter from the University of Heidelberg. Professor Adler, now very elderly, informed him that the university had decided to confer upon him an honorary doctorate in law for his contribution to the development of international humanitarian law. Martin accepted the honor with gratitude, but said in his acceptance speech that the true recognition should go to his family and the other victims of Ravenstein. It was for them that he had fought, and it was their memory that had given meaning to his work. Erich Vollmer died in 1977, at 62 years of age, from a heart attack. He spent the rest of his life as an accountant in Stuttgart, never facing a second trial, never admitting his guilt. But his acquittal, once considered definitive and unassailable, had been emptied of meaning by Martin's work. No other commander could use the Vollmer sentence as a shield. The precedent had been overturned, not formally but substantially. Martin Kreuzer died in 1992 at the age of 70. Until the end, he continued working on war crimes cases, offering his expertise free of charge to anyone who needed it. In his study, hanging on the wall, there was a black and white photo of his family, taken in the summer of 1945, a few months before the massacre. His father, his mother, his sisters, all smiling at the camera, unaware of what would happen. Next to the photo, Martin had framed General Kreutzer's dispatch. It was that document, found after years of stubborn research, that had transformed his anger into justice. In the years after his death, Martin's work continued to influence international law. The Kreuzer principle was cited in trials at the tribunals for the former Yugoslavia in the 1990s, in trials for genocide in Rwanda, and finally was incorporated into the Rome Statute that established the International Criminal Court in 1998. Article 33 of the statute, which establishes that superior orders cannot be used as a defense for war crimes when the order was manifestly illegal, directly reflects the principles that Martin had articulated in his memorandum of 1954. Today, in Ravenstein, there is a small memorial dedicated to the 37 victims of the massacre of November 5, 1946. It is a simple gray stone stele with the victims' names engraved. At the base of the stele, there is a bronze plaque. The plaque reads, "In memory of those who were unjustly killed, and of Martin Kreuzer, who did not allow their death to be forgotten or trivialized. His search for truth changed the law and protected countless future lives." The memorial is rarely visited. Ravenstein is a small village off the tourist routes, but for those who visit it, the memorial tells a powerful story. The story of how an ordinary person, armed only with stubbornness and an unshakable sense of justice, can challenge a system that seemed invincible and obtain a victory that transcends the individual case to become a universal principle. The story of Martin Kreuzer and the Ravenstein massacre is not only a story of crime and punishment, but a story of how the law itself can be transformed by the determination of those who refuse to accept injustice. General Krantz's dispatch, a document of a few lines written in a chaotic moment of war, has become a symbol of the fact that even in the darkest periods, there are always lines that should not be crossed, and that those who cross them must answer for their actions. Martin's work demonstrated that justice can be slow, can be obstructed, can seem impossible. But if someone is willing to fight long enough, with sufficient dedication and intelligence, that justice can be obtained, if not for the original victims, at least for those who will come after. And perhaps, in the end, this is the most important form of justice. Not revenge or retroactive punishment, but the creation of a world in which similar crimes become more difficult to commit and easier to prosecute. This is Martin Kreuzer's legacy, and it is a legacy that continues to live every time an international tribunal cites the principle that bears his name, every time a military commander is held responsible for actions that violate international law, regardless of the orders he received. Martin's battle is over, but the war for international justice continues, fought by new generations of lawyers, prosecutors, activists who are inspired by his story. And in this sense, the victims of Ravenstein did not die in vain. Their tragedy, transformed by Martin's work into a catalyst for legal change, has contributed to building a more robust international justice system, more attentive, more capable of distinguishing between the legitimate execution of military orders and the deliberate commission of atrocities, disguised as operational necessity. This is the story that deserved to be told. The story of how a tailor turned legal investigator changed the course of international law, not through force or power, but through patience, meticulous research, and an absolute refusal to accept that injustice could remain unpunished. And if there is a lesson to be drawn from this story, it is that justice does not belong only to courts, judges, professional lawyers. It belongs to anyone willing to seek it, to fight for it, to dedicate their life to ensuring that truth emerges. No matter how long it takes, no matter how many obstacles stand in the way, Martin Kreuzer was an ordinary man who did an extraordinary thing, and the world is better for his work.